Today on Off the Clock, we're going to talk about severance agreements. They've been the talk of the town lately because the NLRB came out with a recent decision that called into question non-disparagement clauses and confidentiality clauses within severance agreements.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. I have to be honest, I'm really glad that we're talking about this today.
Why?
Because I want to know this information as well. I want to
for my hourly rate, I will be
right.
happy to share it with you.
Exactly.
Yeah, lots of clients do too.
Lots of clients do too. And I will say this, I have had lots of questions surrounding this NLRB decision from the General Counsel.
Yeah.
But also, sadly, I'm seeing an increase in the number of severance agreements and separation agreements I'm putting together for clients. So I feel like it's two things converging together, and it has become quite an issue.
In the 10 days after that decision came out, I was helping clients with 2 reductions in forces. Yeah. So we needed to review that decision quickly. Right, and get our thoughts together and our advice together quickly. Right. So for those that have no idea what we're talking about, why don't we pause?
What is going on?
What is going on?
You tell us.
Before we get to the advice. Okay. So the NLRB, the National Labor Relations Board, General Counsel issued a decision that said that, and I'm going to qualify this, some confidentiality clauses and some non-disparagement clauses in severance agreements or separation agreements, I'm going to use those terms interchangeably, they really are the same thing, can violate national labor relations law and be void or invalidated.
And why is that? What part of the law do they violate?
Hopefully most people know, and if they don't, this is a great time to learn that employees have protected rights to discuss certain aspects of their job with each other and with those even outside the organization, right? Terms of employment, conditions of employment,
right.
My supervisor's a boss, I'm not paid enough, right? Those sorts of things are protected rights under law. And so the NLRB found that some confidentiality clauses and some non-disparagement clauses restricted the employee's ability to have those conversations with others.
Interesting.
Does that make sense?
It does make sense. So you're talking about protected and concerted activity.
Protected and concerted activity.
Oh, that's so interesting because I think I would guess a lot of our listeners are familiar with that concept of protected and concerted activity or Section 7 rights. But there hasn't been maybe a lot of thought given to how those apply to separation agreements, to people on their way out the door. So this is really quite interesting. It's an area that when you read it, it makes sense, but is something that not everyone has thought about.
It's never been
used
in that way. And I think perhaps one reason is, I would have argued, and I'm not sure if these lawyers did, well, they're not our employee anymore.
Right.
By definition, we're telling them after they're not our employee, they may not talk about certain things.
Yes.
So it was not clear to me that these rights extended beyond the term of employment.
I see.
For instance. So it wasn't as obvious, but anyway, it's now being applied in a new context. Again, to your point, not new concepts, but being applied in a new context.
In a new way. That's a good way to think about it.
In a new context in severance agreements.
That's a good way to think about it. Okay.
And it also applies to those who do not have unions. So many of our non-union workplaces think that the NLRB or the NLRB is the board, the NLRA is the act, the law don't apply to them if they don't have unions in their workplace, but that's simply not true, right? This decision applies across the board, and employees have protected and concerted rights, whether there's a union in the workplace or not.
Yep.
Right?
Great point.
So everyone needs to listen, and every size employer needs to listen.
Okay.
Right?
No one's excused for today. Got it.
Nope. No hall passes for this one, right? Where you get to skip. So now with that background, which was pretty fast, but I think the concepts are not difficult, frankly, to get our heads around. It's the practical
I was going to say, so what should people be doing?
So the first question I got, not just from my clients going through reductions in forces, but from lots of others too, is should we just take the templates that we have and delete those phrases? Is that all I have to do? Do I even have to talk to you, Rebecca? Is that just the bottom line here? So to that question, I say, well, it's not that simple. I'm a lawyer.
Of course, right? Yes.
Right. Nothing's that simple for lawyers. Let's pause for a moment and focus on one aspect that I've seen people just blow right by, right? I mean, sometimes it's not included in the articles at all, but other times, frankly, we're all busy and we just read the headline and you have to get to the closer to get to this point. This decision that restricts what I'll call overbroad non-disparagement and confidentiality clauses does not apply to supervisors.
Yeah, that's a really important point.
Let's just stop for a beat on that.
Yes.
Okay, because
and why
so
is
many
that? Can you explain why?
So many severance agreements are used for supervisors and managers on up, okay? So a lot of folks that use them, for exempt folks and up. Supervisors don't have the same protections, right? Legal protections regarding protected and concerted activity. So what clients need to know is that who is a supervisor? Obviously, if this matters to clients, they want to keep them in when they can, and that may be a very individual decision, employer by employer. But for those that would like to keep them in to the extent they can, they then have to know who a supervisor is.
Yes.
Sounds simple.
It would, yes, but I'm guessing you're going to tell us it's not.
Nothing simple. Those are colleagues that practice a lot in traditional labor law and unionized environments. Refer to this as a statutory supervisor.
Right.
That's the magic phrase. A statutory supervisor.
It's never a good thing when you have to put the word statutory in front of the word, right? I think that means you have to call the lawyer to find out.
I was going to say, that's good job security. And because I don't memorize statutes well, this is where I take out my reading glasses, which, as I mentioned a few episodes ago, I've begun. Aging before your very eyes. Right. So the statute defines supervisors as any individual having authority in the interest of the employer. Well, who else's interest would it be? But anyway, let me back up. Supervisors are defined as any individual having authority in the interest of the employer to hire, fire, suspend, lay off, recall, promote, discharge, assign, reward, or discipline other employees, direct them, adjust their grievances, or effectively to recommend such action.
Got it.
And, there's an and. Oh, wait, there's more.
You had read so much already.
It's not an extra set of knives. And requires the use of independent judgment. So this is where folks get a little... it's a little cringy because anyone that's dealt with trying to decide whether an employee is exempt or not, et cetera, knows that independent judgment can be very squirrely. Right. How independent, right? Even CEOs report to the board, right? Everyone reports to someone else. So how independent and how effective is the recommendation? Right?
Yes.
So that's where we get into the weeds. So that is when you should pick up the phone and call someone if you really want to keep very broad clauses in your severance agreement and you're not sure whether the person you're offering it to is a statutory supervisor or not. Call us and we will work it out with you.
Yes.
But that is the framework, and that is something that a lot of people are skipping over.
Yeah, and I think that really is an important point. And I think your point about setting aside group reductions, right, or RIFs, these one-off, we've made a decision to end Sarah's employment and we're going to offer her a separation agreement. More often than not, that is usually for an employee at a higher level within an organization.
Yes.
Or often
at least that's when
we
see it, we should say.
That's,
maybe people are doing it on their own with everybody else.
So I think that is an important takeaway for all of our listeners. It might be the case that individual is truly a supervisor, in which case we don't need to water down anything in the agreement. And it could involve an individual, because of the position they've held, for which confidentiality and non-disparagement is particularly important, and we don't want to water it down.
I was just going to say that when we think of what usually employers are most concerned about when they want confidentiality and non-disparagement clauses,
right,
the higher level, the supervisors on up, are going to have that information probably that you're most concerned about.
That's right.
Right? So this is where we can say, everyone take a deep breath.
Everyone take a deep breath.
Because there was a bit of freaking out there that we can't require confidentiality anymore.
Right.
But that's so important to us. So everyone take a deep breath.
Right.
Okay.
So for the employers to whom this decision does apply, what exactly does it allow or not? Does it allow employers to have any confidentiality in the agreements, for example? Let's take the confidentiality piece first. How can those agreements be revised so that there's still some element of confidentiality, but it complies?
So for your non-supervisors,
yes,
right, you can require confidentiality of the severance amount.
Oh,
the financial terms of that. They would, another way to say it is the financial terms of the severance agreement. And so what you would do is that's usually in one paragraph up front in the severance agreement. So you could say paragraph, whatever it is, shall remain confidential. You're fine. No problem with that.
So they can do that. So that's so interesting to me because my experience is that is usually the biggest reason for a confidentiality clause, right?
But they're usually not drafted that way. And I will confess to this. Yes. I mean, the ones I have drafted over the years have been much broader than that. Because as long as we're requiring confidentiality, right, why not throw in
the entire agreement?
Yeah, so we say everything related to your employment, blah, blah,
so
blah.
Even for non-supervisors, we can have a confidentiality clause that requires confidentiality for the amount of severance they're getting, basically, for the financial terms.
Yes, that is the general counsel's
office.
Well, that's
important for our listeners.
The general counsel's office has said clearly that they will not consider that a violation. Okay, so that's clearly on one side.
Okay.
Well, let's talk about some areas that are not as clear, but that we can talk about.
Okay.
I think that for certain employers that have other interests that are very important to them to keep confidential, as long as it's narrowly defined and not the type of information that the NLRB is really concerned about, I think they could consider that. That's something, again, to talk about on an individual basis. But things like financial information about the business, IT information, and healthcare patient information, right? Like other types, again, not the NLRB's concern at all. We're not talking about terms and conditions
of employment.
In the workplace. We're talking about proprietary information of the employer. My gut reaction is that would probably be okay.
So to be clear, we're talking about two different types of confidentiality clauses. The first one is the confidentiality of the agreement itself, right? And what you're saying is you can still have a provision that says the financial terms of the agreement itself are confidential.
Correct.
And the separate type of confidentiality clause is the confidentiality of business information related to the employer. I usually see those in two different clauses in a separation agreement. Which is why I point that out. So
see, I don't all the time. So and sometimes, frankly, with confidentiality, let's just pause here to say, lots of employers who do have information where it's very important that it be kept confidential, they have separate confidentiality agreements.
Oh, of course,
right. And then in the severance agreement, we
just
incorporate those by reference, right?
So with regard to confidentiality of the employer's business information, we can still have those agreements in place. We just need to be careful for non-supervisors not to have an agreement so broad as to include the terms and conditions of employment.
Sometimes they include usually the longer agreements talk about wages being kept confidential, for instance, right? Like that, that could be an issue.
Or employees. I've seen it saying information about any of our employees will remain confidential. That could be a problem. However, to your point, financial information, customer lists, customer information, all of that we can still absolutely have a confidentiality agreement or a provision of separation agreement.
There was some confusion about that. I think just the headlines, and again, I'm not saying this negatively, we're all just busy, right? And sometimes we all just read the headlines. Some employers were concerned that confidentiality
It was misleading.
in general.
Yeah, sure.
Nothing, not just in severance agreements, but that the NLRB was saying you couldn't keep
Okay.
anything confidential.
So we're just full of good news, really, today,
it's
right?
very unusual.
That's
For
right.
lawyers to give the good news. So that's the skinny on confidentiality. On non-disparagement, let's just break down that term, particularly for maybe folks newer in HR.
Yeah, what
right?
do you mean by that?
Because
What do
that's
you
not
mean?
a phrase we just use, right? In common conversation. When lawyers use it, or when it's used in handbooks or in severance agreements, disparaging the company would mean saying bad things, painting it in a poor light, right? Saying things that might have the impact of discouraging people from wanting to work here, discouraging customers from wanting to work with us, et cetera. That is disparaging. And so non-disparagement clauses, the very broad ones, tend to say you shall not say anything that has the impact of
Making us look bad.
Painting us in a poor light, and it even often extends to our management and employees.
And I think this is important because let's be clear, in the context of separating someone's employment, it is often a real concern that individual, things may not be ending necessarily on a positive note, right?
Sure. They're mad. Yeah.
I've had many situations in which businesses were legitimately concerned about that individual going to board members, going to customers, or God forbid, posting on social media their feelings about the organization and saying very negative things about them. So those non-disparagement clauses often have real intention and meaning to those businesses, right?
Yes. I completely agree. Oftentimes, frankly, more important than the confidentiality.
I was gonna say more than even the severance amount. The idea that one of the reasons we're entering into this agreement is so that we can all agree to play nicely with each other,
right?
And we're going to move forward on a positive note,
right?
We'll give the employee a neutral reference. We're not going to throw them under the bus. And at the same time, we can rest assured that we're not going to be spending lots of time trying to clean up messes from this individual going around and saying negative things about us.
Right. Exactly.
Okay.
Yeah.
So for supervisors, we can still have very broad non-disparagement clauses.
So deep breath, because oftentimes those are the folks that can do the most damage.
Yes.
So.
Deep breath. For non-supervisors, is there anything we can still do in those agreements?
I think so. One, again, to the clear side of what you can do, you can prohibit defamatory statements.
Okay.
Now, making defamatory statements already would open them up to a cause of action, right? You can't defame people, which means saying something that is factually
incorrect,
untrue.
Right.
This is important. So if we can only prevent defamation, we can prevent people from saying things that are factually untrue.
Okay.
Opinions
I was going to say
are never defamatory. So let's think about that. So sure, thank you very much, GC, for giving us that. But I'm not sure if that actually helps us that much that we can prohibit defamation. Again, we could always sue for defamation regardless of what's in a severance agreement.
Right.
And it only applies to facts. So as long as the employee says, I think ABC Corp is a horrible place to work that cheats its customers, that may not count as defamation.
But we can still have, to be clear, we don't have to put in the agreement that they're allowed to state their opinion. We could instead, we could still have language in the agreement that sends them the message that they are agreeing not to make defamatory statements against the organization. Sometimes that language is helpful on its own. Let's just talk about that then from a practical standpoint, if that's okay. So what that means then is for non-supervisors, if a business has a true concern about an employee who is a non-supervisor, in disparaging them in certain ways, whether it's talking to their customers or whether it's talking to funding sources or whether it's going on social media, then they're going to, from a practical standpoint, then what I would say is you need to be thinking about how to head that off, right? And thinking broader than the language you're going to put on paper and in an agreement to the employee, right? So how are you going to head that off? Think about your social media platforms and what you might want to do in the short term to prevent somebody from just going on your platform and saying whatever they want.
You might want to turn
because you can
comments off.
control that, right?
You might want to turn
Exactly.
comments off,
And I
instance.
have a lot of those conversations with clients, right, in the moment of these situations too, right? There are other things we can do in those circumstances to try to prevent those concerns or head off those concerns as well.
Because if an employee's angry enough to want to disparage your organization, signing a paper saying they won't might not be enough to stop the conduct in the first place.
That's right. That's right. So I like having what we can in the agreement because that sometimes is an incentive for them to be quiet, but also understanding that they would still be allowed by the agreement to do other things. So be thinking through what else we might want to do.
I also think it's okay to consider, and this should be on an individual basis after some thought and discussion, but if there's something particular that is on the mind of an employer in that moment, think about whether it can be narrowly tailored and still be placed in a non-disparagement clause.
Right.
So, for instance, funding sources is a great, or discouraging clients or customers, right?
Yes.
From coming here and maybe taking their business elsewhere. I think there's a good argument that that's still okay, right? We're not saying don't say bad things. We're just saying you can't interfere with our relationships with our customers, with our vendors, with our funding sources, with our board members. It's something to think about. Again, this is all still being fleshed out right now.
That's a really excellent point. That's a really good point.
Let's think about what really matters to you, right? What really is important, and can we express that in a way that is narrowly tailored, in a way that the NLRB is not going to care about, because it doesn't touch upon protected and concerted activity. And those are conversations I have had. So when I have been getting questions, which I know you have, all of us have, saying we're separating an employee tomorrow. Here's the template we've been using for the past 5 years. Do I have to delete this?
Right.
I pick up the phone and I say, let's talk about this particular employee. First of all, if it's a non-statutory supervisor, is there something that is particularly concerning to you?
Right.
About what? Confidentiality or disparagement. And let's think about whether that's something that falls under protected and concerted activity. Lastly, something we're recommending, which is... it's not proven yet in courts, but we think it's a good idea to put what we call savings language in agreements, which we put in handbooks and other things too, which is something like nothing in this agreement is intended to restrict your rights, right, that are protected by federal law, including the NLRA.
Got it.
Right? That can't hurt. It can't hurt, right? And it may help.
And it may help.
So that's an easy breezy
The other,
fix.
right, and we can also include language in the agreement that makes clear, right, that if a judge finds a certain provision to be overbroad,
right,
the rest of the agreement can remain in place.
Correct.
Right? So, for example, probably the most important part of a separation agreement is the release of claims.
Yes.
Right? So we wouldn't want to accidentally have a non-disparagement clause that invalidates the entire agreement so that we also lose our release of claims. We'd want to have language in there saying if any separate provision of this agreement is found to be overbroad or unlawful, a judge can just kind of carve out that provision and the rest of the agreement can remain in place.
You know, you bring up a very, very good point that I've also been discussing with employers is it's the or what. So I leave them in. So what? Right? What's going to happen to me if I have these overbroad clauses? And one is you run the risk of an unfair labor practice charge, which frankly for a lot of folks, particularly non-unionized folks, doesn't keep them up at night probably. But it's to that point you just raised. It could invalidate potentially the release of claims, which is much more
we don't want.
No.
Yes.
We do not want to do that. Okay. So Should we talk about takeaways?
Yes.
Okay. We want to work on every severance agreement, every employer, right? Ever issues, but we know.
That's probably not feasible.
We know employers have templates, right? And that they use them and they send them to us like handbooks periodically to revise, review, et cetera, when there's a one-off particularly difficult situation. But we know there's templates out there being used, right? And so the takeaway is this is a time to have your favorite employment lawyer review your template, right? And have this conversation with them and talk about, do we want to take those clauses out completely?
How do we want to do
we want to
this?
narrow them? What are we going to do, right? And then I think this is a great time for, just very quickly, but a general conversation about why you can't use the same template every single time, right?
Oh, because there's other...
So there's a few
lots
reasons.
of other reasons.
Let's just run through them quickly because, there's still so many people. Either they knew it and forgot about it. Frank, that happens a lot in the heat of the moment, or they just didn't know about it. So this what we talked about today adds one, right? Statutory supervisor versus non. Because remember, again, for supervisors,
have different language for each.
Yep. So if that is really important to you to keep the broadest in, you can have two separate agreements, one for supervisors, and then one that either removes the clauses or at least narrows them considerably for non-supervisors, right?
Right. And then we've got the federal law called the Age Discrimination in Employment Act.
Yes.
And the Older Workers Benefit Protection Act.
Good for you for remembering each one of those precisely.
Yes, exactly.
And that impacts severance agreements in two ways. First, if someone is 40 or over, which they consider an older worker.
I know,
by
that's
the way,
so
which is very
offensive.
offensive.
It's very offensive, yes.
It was the one reason I was happy to turn 40. But now that I'm significantly more than that, I'm offended. But if you're over 40, there has to be really a section added to your severance agreements because employees over 40 have different rights of review, et cetera. And they have to be told things explicitly, and they also get 21 days to consider the agreement and then a 7-day revocation period. But, and this is a mistake I see folks make in templates where they just add that in, that also then impacts the timing of the payment that's usually towards the beginning. So the Older Worker Benefit Protection Act language usually comes towards the end, but don't forget that usually impacts the timing of the payment because you want to wait for that revocation period to be over, right? Which is usually like paragraph 1 or 2. So if you've got an employee over 40 or under, right, the agreement should be different.
And if it's a group or a single.
And then if it's a group or a single. Yeah, that's the other big differentiator. So a group is 2. Anything more than 2. So you have single or anything more than single. Single, no different than what we just discussed. 2 or more at the same time means they get 45. Employees over 40 get
40 or over.
40 or over, thank you. This is hard to say quickly.
Yeah, it's a lot of numbers.
It's a lot of 40s and 45s.
Yes.
Get 45 days to consider the agreement. And the part that's the disclosure form at the end, and we can discuss that in more detail if anyone's going through this, but you have to list the titles and ages of everyone else in the decisional unit.
Right.
So that they can see how their age fits in.
So suffice to say, there's a lot of templates now.
Yes, not just one.
And let me just add one more layer before we go, and that is also different states have different specific legal requirements. If let's just pick on the state I always pick on, which is California. If you have employees in California, you are going to need a separation agreement specific to employees in California. The same is now true, likely, of New York and some states on the East Coast, Oregon, et cetera. So that's a whole different layer now. So piecing together all of those templates is becoming challenging for our poor HR folks.
And those are remote employees often. And so what I mean, several of my clients do is they'll just say, we're severancing an employee and pick a state who's working remotely. Is there anything different I need to know? And we can answer that question very, very quickly.
Yeah.
Right?
Just don't forget to do it.
Just don't forget to ask the question. But that's a quick question for us.
Anyway, well, thank you so much. This has been extremely beneficial, and I appreciate you explaining it all to us.
It was fun for me.
Thanks, Rebecca.
Thank you, Sarah.